Welcome everyone to today's webinar entitled When FDA Comes a Knockin', hosted by the Georgia Fruit and Vegetable Growers Association and presented by David Durkin of OFW Law, one of the 3 members of the Recall Ready team. This is the 3rd webinar in our Crisis Communications webinar series. Feel free to access all 5 webinars found on the Georgia Fruit and Vegetable Growers Association website at www.gfvga.org. I am Beth Olson, Director of Education and Food Safety for the Georgia Fruit and Vegetable Growers Association, and will be moderating today's webinar. Before we get started, let's go over a few housekeeping items. Please note this is a pre-recorded webinar. But even being a pre-recorded webinar, technology has made it possible for you to submit questions at any time during this webinar. Simply type your question into the question text box. At the end of this webinar, all submitted questions will be sent to us and we will send answers via email. There will be an FAQ housed on the GFVGA webinar webpage of all submitted questions and answers. Secondly, I would like to draw your attention to the handouts box on the right side of the webinar control box. The handout box contains links to today's presentation as well as several other useful items. If you experience any issues with the audio coming through your computers, please make sure your computer speakers are on and the volume is turned up. You may also use the telephone dial-in option. Now, with the housekeeping items behind us, let's get to the introductions. Today's webinar, When FDA Comes a Knockin', will focus on legal requirements of a produce recall and how to meet FDA's expectations during a recall. Again, this is the 3rd of 5 webinars in a series designed to help prepare for a crisis before it happens. Industry experts would agree the best time to prepare for a crisis is not once it happens. And for the large majority of instances, most crises are not expected. This is what led the Georgia Fruit and Vegetable Growers Association to create a crisis communication and management plan for a series of crises in the southeastern produce industry, including foodborne illness, labor, weather, and accidental employee death. This plan is an outline that a GFVGA member can access to create a very specific crisis communication and management plan for their farm or produce operation and for most any crises. The 5 webinars in this crisis communication series are designed to provide high-level information and overview in a short amount of time. After the webinar, if more in-depth technical information is needed, you're welcome to contact me, Beth Olson, with the Georgia Fruit and Vegetable Growers Association, any of the 3 presenters from the Recall Ready program, or attend a Recall Ready workshop offered through the United Fresh Produce Association. Speaking of the Recall Ready team, today our presenter is one of the Recall Ready team trio, David Durkin, a principal at OFW Law Firm since 1998. David's practice is concentrated in federal, civil, and criminal litigation and administrative proceedings, including court challenges to FDA, USDA, and DEA regulatory and enforcement initiatives and ITC proceedings. He has assisted individual clients and conducted webinars on handling product recalls under FDA's jurisdiction, with special emphasis on the recall of perishable products. He has served as general counsel to the United Fresh Produce Association for over 25 years. David has also written several manuals for specialized segments of the food industry regarding FDA inspections and recalls. It is with this wealth of expertise and renown that I now turn the program over to Mr. David Durkin.
Thanks very much, Beth, and thank you to the Georgia Fruit and Vegetable Growers Association for providing me the opportunity to speak to you today. Today, we're going to go over three general areas. A little Food Law 101 regarding what is a recall and why are we doing this? To answer another question, whose recall is it anyway? And to provide you with some handy checklists for dealing with FDA before, during, and after a recall. So, little Food Law 101. I know this is a lot of words on the screen, but bear with me. This is the text of the Food, Drug, and Cosmetic Act of 1938. And it is the definition of what we call adulteration, what you probably call in the real world contamination. So anyway, there are several different ways in which food can become adulterated. Section 1 says if it bears any poisonous or deleterious substance. Section 2, if it contains a pesticide chemical residue that is unsafe because it exceeds an established tolerance, or if there's no tolerance for it at all. 3, if it consists in whole or in part of any filthy, putrid, or decomposed substance. I tell you, they really just don't write statutes like this anymore. And the fourth section, which is kind of the catch-all, or also known as the adulteration as a matter of law. If food has been prepared, packed, or held under insanitary conditions whereby it may have become contaminated with filth, or whereby it may have been rendered injurious to health. This is also known as the dirty warehouse provision. So that's how food can become in violation of the Act. So what is a recall? This is FDA's own definition of a recall. Removal or correction of a marketed product, so it's got to be out there, that FDA considers to be in violation of law. What law? The adulteration or misbranding provisions, and we just went over the adulteration provision, and against which FDA would initiate legal action if it had the opportunity. What a recall is not. A recall is not terms you may have otherwise heard called market withdrawal or stock recovery, and I'll define those in just a second. So remember, in order to be a recall, the product's got to be out there, and it's got to be in violation of law. So, just to disabuse you of the notion that you can get away with this by only doing a market withdrawal or a stock recovery. Market withdrawal, it's a minor violation of the Act or a no violation of the Act. How does this come into play? I have been involved in circumstances whereby people are awaiting confirmation of microbiological testing for ready-to-eat produce products. And knowing that if something comes back for pathogen like salmonella or listeria, that they're going to have to recall product. So in order to get ahead of the game, what do? They pull product back before they have confirmed test results. That's a situation in which a product has been in the distribution channels, there is no violation of the Act yet established, and therefore it is not subject to FDA legal action. That's a market withdrawal. Sometimes those market withdrawals turn into recalls, and sometimes it's an unnecessary exercise. But that's the exercise of prudence on the part of the produce shipper. What is a stock recovery? A stock recovery is a non-marketed product. It hasn't left your control. And like a market withdrawal, there's a minor or no violation of the Food, Drug, and Cosmetic Act. How does FDA hear about recall events? Several ways. Most commonly, it's self-reporting by the firm. Firm calling up and saying, hey, FDA, we've got a problem, and we think we need to recall. FDA can also hear about it by foreign government or other federal or state agencies advising FDA that they have found a problem. A recall event can get triggered by an FDA inspection. It can be triggered by consumer complaints. It can be triggered by your competitors turning you in. Or it can be occasioned by FDA surveillance samples. So we're going to concentrate on recalls. We're not going to concentrate on market withdrawals. We're not going to concentrate on stock recoveries. There are three classes of recalls in FDA parlance, cleverly called enough Class 1, Class 2, and Class 3. And each of them has their own definition. Class 1 is when consumption of or exposure to the product presents a reasonable probability of serious adverse health consequences or death. That's the most serious one. I always thought myself that death was a serious adverse health consequence, but there it is laid out in FDA language. Class 2 is when consumption of or exposure to the product may cause temporary or medically reversible adverse health consequences, or instances in which the risk of serious consequences is remote. And finally, Class 3 recalls are those that are not likely to cause adverse health consequences. I want you to understand the terminology here because it'll get repeated in the rest of my little talk. So what does FDA expect in a Class 1 recall, where product is out there, product could hurt somebody, product could even possibly kill somebody? FDA wants the following: issuance of a public warning. And the contours of those public warnings will be the subject in much more detail of other seminars, or other webinars in this series. FDA wants a press release and the filing of what's called a reportable food registry report. That's a little outside of this. If you have any questions on that, send them in. We'll be happy to answer them. FDA wants immediate notification to the public and the complete cessation of distribution. They want notification to go down to the consumer level. That's why there are press releases. When a firm recalls a product, they want to include instructions to their consignee that if the consignee has further distributed the product, they should pass on the recall instructions. FDA wants product out of the reach of consumers completely. They want you, the recalling firm, to go back and recontact all your consignees to make sure that they understood the instructions and did something about them. They're going to want you to make monthly status or progress reports to the agency, and you should expect to be published in a publication called the FDA Enforcement Report, detailing what happened during the recall. Class 2 expectations: while FDA may not require a public warning, they may ask you to put out a press release. They will expect you to wrap up the recall within 4 months. You will also have to make notification down to the consumer level and include those sub-distribution notifications to your consignees. They will expect monthly progress reports, and you will be published in the FDA enforcement reports. FDA asks, but does not require, that Class 2 recalls be reported to the agency. So what's a Class 2 recall? Foreign objects that could pose a physical hazard, such as foreign material. Certain pathogens which, while unpleasant, will not kill you, like Shigella, Hep A, Cyclospora, Cryptosporidium, although I will point out that Cyclospora and Cryptosporidium may get kicked up to Class 1 level in the near future. And certain undeclared allergens, wheat or coconut, which can be unpleasant if you have sensitivities to those, but they won't kill you. So what's a Class 3 recall anyway? Well, filth, sulfite levels, low sulfite levels, food spoilage. That's really not something we have to concern ourselves with the produce industry because distributors and retailers are constantly culling our product anyway. Short fill weight, low levels of pesticide residue that do not, which render the product adulterated, but if it's a low level that won't harm anyone, that could be a Class 3 recall. So I've heard all of this in the course of the decades that I've been doing this business, about people in the produce business that say, why do I have to recall? The stuff's gone by the time we find anything wrong, or we don't have any indication that all of the product was adulterated. There were only a few illnesses. This next one is one that I recently heard that I just love. This is a raw agricultural commodity. It's supposed to have pathogens in it. No, it's not. And distributors are going to return more product than is covered by the recall. Absolutely true, unfortunate, and there's nothing anyone can do about that. So why do we recall? This is more the Food, Drug, and Cosmetic Act. The following acts are prohibited. The introduction of food that is adulterated, the act of adulteration or misbranding of any food, and the receipt of any food that is adulterated. So if you send adulterated food, if you adulterated food, or if you receive adulterated food, that's prohibited under the Act of 1938. Say, okay, I shouldn't do that. It's against the law. What are the consequences? The consequences are criminal. It's at least a misdemeanor to ship adulterated food, to adulterate food, or to receive adulterated food, punishable by up to a year's imprisonment or fines, as you can see on the screen. If you do it with the intent to defraud, it becomes a 3-year felony, and each shipment is a separate offense. Like, wow, that's pretty heavy. Well, it's a good thing I'm completely innocent. I didn't know anything about the adulteration. Too bad. There's something called the Park Doctrine. The Park Doctrine is a series of Supreme Court cases that impose special obligations on people operating in the food business. The Food, Drug, and Cosmetic Act imposes on person exercising authority or supervisory authority not only a positive duty to remedy Food, Drug, and Cosmetic Act violations as they occur, but also an obligation to implement policies and practices designed to ensure against future violations. That's good law from the United States Supreme Court as recently as 1975, and park prosecutions are carried out by the FDA each and every year. This all goes back to an old case that was decided by the Supreme Court only 5 years after the passage of the 38 Act. And they said that the Food, Drug, and Cosmetic Act dispenses with the conventional requirement for criminal conduct, awareness of some wrongdoing. In other words, you don't have to know you are violating the act. You've committed a crime. Think it can't happen to you? The Jensen brothers didn't know that what they were doing to those cantaloupes was going to cause them to become contaminated with listeria, but nevertheless, they were criminally charged. They ended up not serving any jail time, and they turned over all of the proceeds of their lawsuit against their auditor to the victims, but no one wants to go through that. But it can happen in the produce business. As a matter of fact, it is the Department of Justice policy that in the event of a foodborne disease outbreak resulting in any deaths, DOJ will open a criminal investigation. And even if they decide against prosecution, going through a criminal investigation is no fun. But wait, there's more. In addition to criminal prosecution, FDA has all of these other enforcement powers. Administrative detention of product, which in the produce business is a death sentence. The states have administrative detention authority, stop sale orders. For imported product, there's import alerts, or as it's more formally known, detention without physical examination. Product gets stopped at the border. Again, that's a death sentence in the produce business. For registered facilities, processors, they can suspend your registration and put you out of business summarily. They can go into court and get an injunction against you. They can seize the product. Now, under the Food Safety Modernization Act, FDA has mandatory recall authority. And one of the worst things FDA can do to you is engage in publicity, to say you're not cooperating, to say your company is not protecting the public health. And nobody wants to deal with that. So you have to think of a recall as the corrective action that you take in order to persuade the federal government to not prosecute you. Why are we concentrating on this? Well, in the produce business, we generally, or for a lot of commodities, we can't rely on a consumer kill step. Certainly, all those lovely Georgia peaches get eaten raw. Well, the ones that are baked, they may have a kill step, But FDA would still want you to recall them because there's no guarantee that a consumer is going to adequately cook it. And pathogens of concern leading to produce recalls are consistently Class 1 recalls, so you have to understand how to handle the most serious kind of recall there is. So, whose recall is it anyway? Well, FDA envisions it in their way of thinking and protecting the health, that the firm with the primary responsibility for the manufacture and marketing of the product is the recalling firm. In the event of a Class 1 or Class 2 recall, FDA will insist that the public notification, be that the press release or other statements, be in a manner most likely to aid consumer identification with regard to brand, package configuration, unique identifiers. We call this the grandma test. If grandma hears about this, is she going to be able to go into her refrigerator and identify the product that's under recall? So what does a recall look like? I'm not expecting you to be able to read this, but this is a screenshot of the FDA website where they publish the press release that you do for them. And so it's up on the internet, and so it's forever, but they publish your press release. The food safety community will pick it up and also publish it on their blogs. Oh, and by the way, I'll just note, I use this one because it's a little story from Bill Marler's blog about Jack and Peter DeCoster, who went to jail for shipping adulterated eggs and we were contaminated with salmonella. Oh, well, who eats raw eggs? Some people do. Some people don't adequately cook eggs. There's a pathogen in it, in a product that could be ready to eat. It should have been recalled. They violated the act, and they went to jail for it. FDA will also, under certain circumstances, identify retail establishments where recalled product has been shipped. They will do this in circumstances where the food is not easily identifiable. Think about a piece of fruit with just a PLU sticker on it. And the food is likely to be available for consumption. Sometimes that second factor works in favor of the produce industry because often by the time a problem is discovered, food is already moved through the distribution channels, so it's unlikely to be in consumers' hands. You should also be aware that in the event of a Class 1 recall, FDA, when they come to investigate you, and they will have expanded records access authority if they choose to. It has been the case that if there's a reasonable belief that food presents a threat of serious adverse health consequences or death, the very definition of a Class 1 recall, FDA has access to all records regarding that article of food. Well, now if they want, they can give you a letter that says we're invoking our enhanced records access authority, and they can have access to all records not only to that particular article of food, but any other article of food in your facility that may have been similarly impacted. So, dealing with the FDA. Well, down there in Georgia, you are fortunate that the recall coordinator in FDA's Atlanta district office is a perfectly reasonable person by the name of Emma Nesbitt, and there's her contact information. If Ms. Nesbitt is not available, she will have a backup. And dealing with the Atlanta district office is not necessarily unpleasant. You should consider calling up Ms. Nesbitt and introducing yourself before you have to, perhaps even inviting FDA to come out to your facility so that they understand your operation and your dedication to food safety. If you need a recall coordinator from somewhere outside of the Atlanta district, those can be found through that link on the FDA website, that second link there on the page. If you have a recall, especially if you have a Class 1 recall, you will receive an inspection, and you will receive an inspection shortly. If your recall is associated with an ongoing foodborne disease outbreak, you will receive an inspection almost immediately, within a day and a half. So preparing for that inspection is mighty important. You should have written policies regarding how you're going to, what production records you're going to turn over and which ones you're not. And remember, that can change if they invoke their special records access authority. You should have a written policy over whether or not and under what circumstances you're going to turn over any testing records, be they product testing records or environmental monitoring records. You should have a written policy regarding the circumstances under which FDA will be allowed to take photographs within your establishment. And you should have a written policy regarding the conditions under which you'll turn over sales and financial data, because FDA, although they ask for it often, they're not really entitled to it unless they request it in writing, and then cannot use it against you in court. You should have already designated liaisons within your company to deal with FDA, because in the middle of a crisis is not the time to try and decide who would be best to do that. If you hear at any point during an FDA inspection one of the investigators utter the words "failure to permit inspection," call a timeout and call your lawyer, because they're accusing you of yet another crime. It is a crime to refuse to permit inspection under FDA's statutory authority. If FDA wants to invoke its special records access authority, it has to do so in writing by a letter from either the local district director or the Center for Food Safety and Applied Nutrition, CFSAN. That's the office within FDA that has jurisdiction over foods. That last italicized, bolded statement, I need to say that this talk does not constitute formal legal advice. It's for informational purposes only. But I have never in my life ever advised a client that it was okay to sign an affidavit prepared by the government. You don't know what it's going to be used for. They can't even tell you what it's going to be used for. They may not know, but you are under no legal, no regulatory, not even a moral obligation to sign an affidavit prepared by the government. Dealing with FDA while a recall is going on. This is a quick checklist of the written information that FDA is going to be asking of you. Product descriptions, examples of the labeling. They'd like to be able to post photographs of your labeling when they post your press release. Coding information and how the codes on your product should be read. Identifying who was responsible, to the best of anybody's knowledge, for the adulteration and why it happened. Whether or not there have been any illnesses reported with respect to the recall product. Often there aren't. They're going to want to know to the case count, to the pound, how much product was out in commerce, what its expected shelf life is, and where it went. They're going to want to know about your written recall plan, which if you're a registered facility, you should have, and if you're just a farm, you might think about writing one anyway. They're going to want to know who their primary contact within your organization is. They're going to want to know who the president and CEO is, the most responsible person. They're going to want to know who's the contact for your customers, the stores you've sold to or distributors you've sold to, and who the contact is going to be for the general public if they want to reach out to your company. The FDA will audit your strategy, and you should discuss how that audit is to be carried out with the recall coordinator. Recall coordinators are there to help you. If you cooperate with them, things will go a lot more smoothly. If you demonstrate that you know what you're doing in performing a recall, they will go even more smoothly. As I previously noted, effectiveness checks in Class 1 recalls, you're going to have to go back and check again with every consignee that they receive their instructions and they understood and did something about them. If it is a Class 2 or Class 3 recall, you should discuss with your recall coordinator what your effectiveness check levels may be. It may be 50%, 75%. They want to figure out how effective your recall was. Effectiveness checks can, however, be built right into the recall notification. Let's say you have a recall and you send out notification to your consignees by email. You can put a response form at the end of that notification that's saying, please acknowledge that you've received these instructions, you understand them, and indicate what steps you are going to take in response to our instructions. And put that right in the initial email. When that comes back to you, your effectiveness check has been done. If you do not perform effectiveness checks, FDA will consider that your firm is not meeting its obligation and responsibility to protect the public health, to protect the consumer. If, in the event, you have a consignee that simply is not responding to your public notification of a recall, feel free to rat them out to the recall coordinator. FDA is not shy about going to a consignee who hasn't responded to a recall notice and saying, what are you doing about this? In the produce world, recalls may be over in a matter of days. And once that is over, you're not done yet. Because, as I've said, there will be inspections after a recall, especially a Class 1. So in dealing with FDA, this is the checklist for what you should do. The Form FDA Form 483 is the list of inspectional observations. It's the write-up you get when your place receives an inspection. You should respond to the observations in 483s and in any subsequent warning letter or other correspondence to the agency. You should respond in writing. You should provide updates to the recall coordinator on a schedule that you and the recall coordinator will discuss and decide upon. You should prepare for that follow-up inspection, clean up as much as you want. You should review and revise your SOPs as needed, because if you had a recall, something needs to be checked and something may need to be changed. You should retrain your personnel, and you should document it all, because in the world of regulated entities, if you write it down, that's exactly what happened, and if you don't write it down, it never happened. So as a result of the follow-up inspection, there may be a further list of observations, Form 43 issued, and something called an Establishment Inspection Report. The Establishment Inspection Report is the written narrative that FDA produces regarding the entire course of their investigation of your recall. You are entitled to get that EIR when the investigation is over, and that is the clearest sign that you're done with this recall and you're done with the inspection. If FDA finds objectionable conditions, however, they may issue a warning letter. They may take any one of the listed enforcement actions, which they could have taken earlier on, but they may take them again. And please remember that the states generally have parallel authority to engage in almost all of these things, including inspection, administrative detention, and even criminal proceedings. That is a brief overview of how to deal with FDA during the course of an inspection when they come a-knockin'. I'll look forward to any written questions that anybody has. I thank you for your attention and your commitment to food safety. I'll hand it back to Beth. Thanks very much.
Thank you, David. That was fantastic. That was a lot of information in a very short, compact presentation, and which is exactly what we're hoping to provide our attendees today. So this guidance in legal requirements of produce recall and how to meet those FDA expectations during a recall is invaluable. Again, this is how to prepare for a crisis. So we're not waiting until we're in the middle of the crisis to to access this type of webinar or to get to know Miss Emma Nesbitt in Atlanta or anything like that. But if you do find yourself in the process of an FDA inspection or any other type of crisis, you've got the Georgia Fruit and Vegetable Growers Association as a resource. You've got David Durkin as a resource. And so that is what all of this is here for. To remind everybody, and as you continue to listen, this is a pre-recorded webinar, but you can still submit questions that we will answer. To submit a question, please type your question in the question text box and press the send button located next to the box. At the end of the webinar, all submitted questions will come to us and we will email all answers to the individuals. We will also keep a running FAQ document on the Georgia Fruit and Vegetable Growers Association's Crisis Communications and Management webpage. In closing, thank you again to David Durkin for sharing your time and expertise during this webinar. It's great.
Well, thank you, Beth.
You are very welcome. It's great to know that we have such a resource and a wealth of knowledge as a friend to the Georgia Fruit and Vegetable Growers Association and an ally for the produce industry. So thank you for that. Additionally, I'd like to thank every one of you who have joined in. You will be receiving a post-webinar survey to provide feedback on this webinar, as well as to help guide us on future topics. Please feel free to contact the Georgia Fruit and Vegetable Growers Association or David Durkin or any of the other members of the Recall Ready team with further questions. We encourage you to explore the handouts box on the side of your screen for useful tools related to today's topic. Thank you for your participation in today's webinar. This concludes today's program.